Okay, we're going to start the webinar now. My name is Chuck Baxter. I want to welcome you to this seminar on managing intellectual property risks and improving your peace of mind, being presented by Intellectual Property Insurance Services Corporation. Like I said, my name is Chuck Baxter. I am General Counsel and a Senior Underwriter here at IPISC. We're going to be walking through some of the things about intellectual property insurance and how that can help you and your clients. A little bit of housekeeping. We're planning to go right about an hour here. And if you have questions, please type them into the questions box. We'll deal with those as we go along or at the end of the session. So let's go ahead and take a look at what we're talking about when we talk about intellectual property. Intellectual property, the products of the mind, are generally grouped into patents, trademarks, copyrights, and trade secrets. And in that area, patents protect inventions, new things that are new and useful that have not been disclosed or known before. Trademarks are ways of identifying the source of products or the services. Trademarks can be the name of your company. They can be the name of your product. It can be anything that's used to identify the source of goods, such as a symbol. It can be the arches, the double arches for McDonald's, or the Nike swoosh, or even the color pink for Owens Corning fiberglass insulation. Copyrights protect original work of authorship, such as literary works, music, art, and especially these days, a big part of copyright protection is in the world of software. But you also see music, you see it in text, you see it in anything that can be considered a work of authorship. And trade secrets are the information that derives economic value from being kept secret. So confidential information or trade secrets can be protected. Trade secrets can be the secret formula for making your food or making your drink. It can be the particular way that your manufacturing line operates. It can be a customer list, can be a trade secret. All those things can be protected under intellectual property trade secret law. So when we look at this type of law and this type of area, the numbers can be bigger than people think that they are. The average cost, according to the American Intellectual Property Law Association, the average cost of a patent infringement litigation, that's the lawyer costs, the cost of expert witnesses, the cost of getting through a trial, is $2.8 million for each side, where the amount in controversy is between $10 and $25 million. These are numbers that we're getting from the American Intellectual Property Law Association. They survey their members. They say, how much does it cost to get through a case like this? Patent cases can be among the most expensive type of litigation that you might get into as you go through. Trademark or copyright litigation doesn't quite cost that much unless there are really high profile things at risk, but it still can be extremely expensive, and specialists in this kind of law can be among the most expensive lawyers you can get. Generally, getting through one of these lawsuits disrupts your business for somewhere between a year and a half and 3 years. It's not an easy thing to get through. It's not just the money, it's also the disruption to your business. Since 2010, we've seen a 40% annual increase in the number of patent lawsuits that are being filed, and just the second quarter of 2015 was the biggest quarter ever for patent infringement suits filed. So it's an area where things are not going away. This is an area where there continues to be an uptick in conflict. And sometimes people think, well, don't I already have insurance that covers that? Generally, commercial general liability policies have an advertising injury provision that has some coverage for some kinds of trademark or copyright if it arises only from the advertising. Generally does not cover patent litigation at all unless the patent is specifically over a method of advertising, and none of that would apply if the claim was over the product that you are actually selling. So we talked about the AIPLA numbers on how much it costs to get through this sort of case, and the numbers in patent litigation are actually going up for 10 to 25 million. The 1 to 10 is 2.2. If you average those, they come out, if you put the whole group together, at 2.8. If you're not fighting about as much, generally people don't spend as much in getting through a case like that. Trademark litigation. Now, let's go back to that first number there. Patent litigation. If the amount that in controversy, the amount they are fighting over is less than $1 million, they still spend an average of almost $900,000 for each side to fight over less than $1 million. Think about that. They're spending more than the case is worth sometimes. Oftentimes in intellectual property disputes, there's more than just money involved. Sometimes it's family members, sometimes it's ex-employees. There can be some bad blood. There can be some things that drive up those costs. In the world of trademark litigation, you're still talking about $1 million in legal cost if you're fighting about a dispute that could be worth more than $10 million, likewise for copyright litigation. So these are not cheap cases to get through. And they happen more often than people sometimes think. This study looked at the number of patent lawsuits filed in the federal court system compared to the number of shareholder derivative actions or stockholder lawsuits, where stockholders sue the corporation for mismanaging the assets. And that is the sort of claim that often leads to a director's and officer's liability insurance claim. Just about every company has a D&O policy routinely carrying coverage against those about 300 cases per year that go on. But look at the number of patent cases. 2, 3, 4, 5,000 or almost 6,000 in 2013, the last year we had those particular numbers available. So who has a risk to be involved in something like this? Any business hold intellectual property can experience infringement. They may need to enforce what they have. If they have a patent, they know they have a patent. If they have a name for their business, or if they have a name for their product, or if they have something that lets people know where they are, they have trademark rights, even if they don't have a federal registration. If they create any sort of graphical or written materials or media materials, they will have some copyright rights. I sometimes will ask, how would you feel if someone opened a business across the street doing the same thing that you do and using the same name as you do? Well, that would confuse people, right? So that would be a trademark violation. That would be a trademark claim you might have. So you might need to enforce your rights there. On the other side, every business is at risk of being accused of infringing on someone else's intellectual property rights. Like I said, if you use any sort of graphical or written materials, there's copyright claims. If you have a name for your business or a name for your products or services, that's a trademark risk. And the patent law says anyone who is making, using, offering for sale, importing any goods or services can be accused of infringing on a patent for that. There can be an invention involved there. So we have examples that we will go through a little bit later about people who've been through the enforcement side and used insurance, or been through the defense and used the insurance to help them get through that dispute and get back to what they do, which is managing their business. I mean, if you don't have insurance, what do you do? Do you just give up? Do you just fold up shop and close your business? Do you need to, somebody may pressure you into trying to take over ownership interest in your business. They may try to keep you from selling your products or your processes or your services. You're going to be spending money on this dispute rather than being able to put that into your business. You're going to lose market share if someone else is in the market selling what you sell, and you're not able to meet that market because they're in there. You may not want to cut a deal, but you may be forced to if you can't afford the fight. So why would you look to us? Why is IPISC going to be there to help? Well, we've been at this for 25 years. We just last week celebrated 25 years of being incorporated as a company that will offer insurance for intellectual property risks. So we've been through this. We've been through a lot of this. We have kept a market open and kept carriers involved so that there will be products available on the market for this. We are the experts. We've been there. We've been through these. We help people get through this sort of challenge, and we can help offer different kinds of coverages to help people getting through whatever sort of risk they might be facing. We do help them by talking to them. We do help them get through this. Like I said, we've been there. We can help direct them to people who can, say, a law firm that can get the most bang for the buck on what benefits that they have, so that they don't have to get halfway through the case and run out of money. So we try to keep it simple. We try to help. This is not the most simple kind of insurance out there. We recognize that. And so we try to help people understand it as best we can. And we're there as a resource. We're there where perhaps you as a broker or you as a risk manager may not understand all the parts of how this insurance works. We are here every day, every business day. We have people on the phone straight through the day, all the time, talking to people, helping them understand how this works. Like I said, for 25 years, we've kept this market continuously open, paid many millions in IP infringement claims. We've taken cases all the way to the U.S. Supreme Court if need be. And sometimes when we are helping people get through litigation, we can help them be more efficient at it and can save them as much in their co-insurance as they had paid previously in their premium. So the whole idea here is to transfer that risk, to move some of that risk away so that you're not shouldering that entire burden all on your own. Your cash does not need to be completely dumped into the litigation. Sometimes that's what your opponent is trying to make you do because they have other business reasons to try to run you down. The cost of getting into this is not just the money you put out, it's what you could have done with that money. And so we're there to help you in getting through that. And it means your products or your intellectual property have more value because they are protected. And there is a backstop. There's a way to help you get through any sort of conflict you might get in regarding the intellectual property risk there. A lot of times we see the big benefit to having this sort of insurance is that it just levels the playing field. And what we mean by that is you don't have to resolve the dispute based on who has deeper pockets and who can pay lawyers longer. You have the resources there that you can get to a decision on the merits. And a lot of times when the other side recognizes that, that changes the way that they are dealing with you and the way that they might be able, the willingness they might have to actually settle that case on reasonable terms or fair terms. So here at IPISC, we have two core products, two main products. And these are the ones, the enforcement insurance, the intellectual property enforcement insurance. We sometimes call that abatement because it's used to abate or to stop others' enforcement. It's a unique plaintiff's policy to help you enforce your rights. And think about that. Where else in insurance do you get money to be the plaintiff, to go after someone? That's not a common use of insurance, but that's the way it works for intellectual property. And it is different. There are some things about it we'll talk about in a little bit that are different from other kinds of insurance you may be familiar with. The defense insurance, on the other hand, is like a lot of other kinds of insurance in that defends you if you get, helps you to pay your defense if you get sued. And it fills a gap where the commercial general liability policies used to have more coverage for that sort of risk, and they have consistently cut away at what they offer there. So there's very, very little left in the advertising injury provision that might give you coverage against some, but not all, intellectual property sorts of claims. So having specialized insurance is important so that you can deal with that. Aside from those two core products of enforcement or defense, we have some other things that we do offer here. One of them is what we call multi-peril, which is a first-party coverage. It pays the losses of the insured. It's not paying money out to the lawyers. It's not paying money out to the other side as damages or settlement. It goes to the insured for the cost of business interruption or the cost of remediation or recalling the product if it was found to have been, if the product was found to be infringing and they have to pull it off the shelves, it can help cover those costs. We offer a little bit of that in every single policy for no additional premium. And you can buy more of it if you want to. We have an unauthorized disclosure of confidential information policy that is coverage for the unintended exposure of a third party's confidential information that was entrusted to you for under a contract. Our Invent Pro is a smaller version of our enforcement insurance. It's kind of a starter version. It's for startups or small companies that if they have a limited number of patents or trademarks that they want to cover. Sort of a way to get into it. A little bit of insurance is better than no insurance, and having that can help you get through the first stages so that you know where you stand and you can get cases resolved, or sometimes there's just not enough to fight over, but you need to be able to get through that first piece, and just having the Invent Pro insurance can help you get there. We have a troll defense insurance where we can look at the non-core business activities and offer you coverage as against known pre-identified patent trolls or patents that are related to trolls. And there's been some news over the past couple of years about there was a scan to email patent. There have been Wi-Fi patents where they've gone after coffee shops and small businesses and people who were just using those business tools. That is something that we have a coverage available for. We are putting into place a coverage for patent owners to be protected if their patents get thrown into a America Invents Act action, a post-grant proceeding trying to take away their patent rights. And that was part of patent reform, making it easier to challenge the validity of patents at the patent office even after they've been issued. We have a policy that we are rolling out that you can put into place to cover you as a patent owner having to respond to those sort of things. And finally, we have an asset-backed intellectual property insurance to help you use your intellectual property as collateral for a loan. We have banks looking at this. Banks would love to be able to loan money and take as collateral intellectual property, but they don't always know what to do with that if they would have to foreclose on it. They're familiar with what they would do if it was a piece of real property or a fleet of vehicles or whatever. They've been through that. It's a way to make lenders more comfortable with unlocking the value of intellectual property as collateral for loans. Some of the other things that we do in our policies, our copay and our self-insured retention do not erode your limits, unlike, say, a deductible in some policies that does erode the limits. There is no erosion of the limits when you're in your self-insured retention or from your copay as you're going through the litigation. The insured controls the lawsuit. We don't jump in and defend using our lawyers and not asking the insured what they want to do. The insured is the one who decides what to do. And if we've authorized a lawsuit, we don't have an out where we say, hey, this is not looking good, we're going to stop covering it. If you see other policies out there, look very closely at the control issues once there is litigation, because we have seen some out there that appear to say, basically, if the insurance company doesn't like the way things are doing, they can just pull out and stop covering it. Once we've authorized, we're on that case. If there is a recovery of funds, if you do get something back, we share that pro rata with the insured according to how much each of us has put in, rather than jumping to the front of the line and insisting that the carrier's money goes first. So who does this really work for? We see small, mid-sized companies and startups using it to help level the playing field so that they can get through a case and not be hurt as much. And we're also seeing large companies, especially where there are divisions and business units that have their own profit and loss responsibilities, having the insurance. Now, if you're a super mega corporation, you really don't need the insurance money to get through it, but you might require indemnity and insurance from your suppliers or your licensors. Policy limits we can offer are up to $5 million, which we hold the pen for here at IPISC. If you are looking for more than that, We can go to our carriers. We've been in the business for 25 years. We can put together a deal to get you more limits if that's what you need. We can offer coverage anywhere in the world and policy terms for up to 3 years, which is really attractive in, say, a mergers and acquisitions situation where someone wants to escrow money as against the potential of having to deal with a lawsuit over infringement. Instead of escrowing a big chunk of money, they can use a smaller amount to buy an insurance policy, which makes more money available to the seller right away. If you need financing, we can handle the financing, and every one of our policies comes with litigation management services to help you get through that case. And that's an important benefit here. Even when you're in your self-insured retention, these litigation management services will help you get through this. They will help you figure out what you're going to do and how you're going to do it, and help you ask the right questions and help you establish the relationship with the law firm so that you have some degree of control and you have somebody here at IPISC reviewing those bills and making sure that they are consistent with what the lawyers agreed their terms would be when they were getting into the case. Like I said, we start doing it even while you're within your retention. We can stay with you all the way to the Supreme Court. We're going to talk about that in a little bit. It's an important service that we have had our insureds like Octane Fitness say to us, that was important. That was a big part of helping us be comfortable with how we were going to get through this. So when we look at an application for defense insurance, our underwriting team gives some indication. We will give you, not just a quote, but we will give you information about what the risk is and what's out there, and try to understand your risk. And sometimes our response can be valuable to a company, even if we did say, here's something we cannot provide insurance going to be excluded. That's valuable information because maybe you didn't know that there's somebody out there who has a patent on that very thing that you're going to be doing. You had no idea you were going to be walking into that landmine, and now you do. We can help you understand the area, the technology space that you're going into. So people ask, how much does this cost? What are the terms going to be? And here are some examples of people that we've had insured on the enforcement side in a variety of different contexts, from management consulting services to software technology, with enforcement limits between $1 million and $3 million per claim and in the aggregate, self-insured retention examples there, and premiums. Premiums generally are a little bit less for enforcement than they are for defense. On the enforcement side, you have the control over whether you or whether you don't. On the defense side, you don't. You don't know. You don't have control over whether somebody's going to sue you so much. So, we do see higher limits available because you might have to pay damages on defense, but we also do see higher retentions and higher premiums. We've got premiums, example premiums here from $14,000 up to $88,000 a year. We do have some premiums that come out less than that. We have some premiums that come out in 6 figures per year. It all depends on what is being insured. There's not really a simple take a card off the shelf and give you a formula for how much your premium will be. What we can do, though, and people want to know this, they don't, they might be afraid it's going to cost too much, or they might be misinterpreting, think it's going to cost too little. We can do a one-page premium indication. If they just tell us what they want to cover, we can look at it, come back and say we think it'll be around this amount, and that helps to calibrate where are we standing. Does somebody think that this is going to be a 6-figure premium when it's really only going to be $20,000 and they can't afford it, and so you're not going to lose them as a prospect? Or is this somebody who thinks, why can't I get this insurance for the same price I cover my 2001 Civic? And it turns out to be more, and we don't want them to be surprised. We want people to understand what kind of ballpark that they are getting into. So the types of companies that we're looking at for this sort of thing, I mentioned the small, early-stage startups, mid-sized companies, and they may need to enforce the things that they've come up with, their own intellectual property. You may have heard of patent trolls. Patent trolls may sue you over patents that you didn't expect. The flip side of that is what's sometimes called a grasshopper, someone who sees your idea and jumps on it and rips you off, does a knockoff, and pretty much says, what are you going to do? Sue me? You can't afford to sue me. If you have insurance in place, levels the playing field, helps to get you into the game so that you can assert based on the merits. And that's all you can ask. All you can ask is a fair hearing. But if you don't have the money, you can't even get that. Big companies we're seeing using contractual terms to require that their licensors or their suppliers not only indemnify them if what they're providing is found, it triggers infringement, but also to carry insurance so that they don't have to put that out from their own money. So let's get into enforcement insurance. Let's talk about how this works. Anybody who has patents, trademarks, or copyrights has a strategic business asset. That's an important part. It may be more valuable than all of their hard goods, all of their bricks and mortar. Give me the Levi's trademark or the formula for Coca-Cola, and that's all I need to form a jeans company or a soda company. I don't need the rest of it. I can get that if I have those secrets or those trademarks or the patents or whatever it is that is your secret sauce to make you successful. People don't usually put that in their budget. They don't think about, what if I have to get into a lawsuit here? But it happens all the time. If you have an attractive technology, people are going to look at it and say, hey, I can sell that too. What's going to stop me from doing the same thing that they're doing? So if you have an enforcement policy in place, it pays the legal costs to go after someone. And so you don't just outspent and give up because you can't afford to stay in the case. Get to a decision on the merits if you need to. And we do see people finding out that you have insurance and wanting to stay away from your technology. So I had a question about the trigger for the enforcement insurance. And the enforcement insurance is one that has here on the third condition, you do have a condition that whatever is already happening is not going to be covered. And you know this from other kinds of insurance. There are pre-existing exclusions in just about every kind of insurance that you have out there. Enforcement insurance is the same way. If your house is already on fire, you can't get fire insurance. If someone's already infringing on your patent, you can't get infringement insurance as against them. So if the thing is already happening, insurance has to be there for something that might happen or it might not happen. And in that case, it's already happening, so that's not going to be there. So the trigger for the enforcement insurance is that someone else begins their commercial activity after you have the policy in place, and their infringing commercial activity begins after you have the insurance in place. Now, if you go through the case and you win the case, the enforcement policy, now remember, we talked about this enforcement insurance being a different animal than other kinds of insurance, and there is a provision in it that you do have to pay back to the policy if you are successful, if you win your case. Now, if you bring your case and you lose, that's been insurance paid for it, that's it. If you bring your case and you win, you've either gotten money in the form of a judgment or a settlement or an ongoing royalty, or you've at least gotten your competitor out of the marketplace so you can sell more of what you make money on. If that occurs, you do have to pay back the amount that the insurance policy put in to help you get there. But if you don't get enough cash back, then, and we call that whole system economic benefit. And it has been an idea. We've seen some other carriers with similar types of coverage pop up in the past 2 decades or so in Europe. And everybody's had some variation on this, that if you win, you pay back. Now that reinstates your policy limits, so you can use that money to go after another infringer. We had somebody who had multiple infringers, went after one, settled, got money, put it back into the policy, went after another one, and after many years, they finally have only just resolved their fourth one on one set of 4 different claims they've put in at one time. So if you don't have enough to put back in under our coverage, you can be forgiven for $100,000 of that. One of the things we will do, we call early intervention, and that is that we will write a letter to someone that you suspect of infringing, and we will say, we want you to know that this party has this intellectual property, and we want you to know that they have insurance for it. So let us know if there's a reason why you think that you're not infringing on this. It's a way of getting free discovery. It's a way to put them on notice and often to get them to go away and stop doing the thing. We see about 70% of the time we send that notice and they stop doing whatever it was they were doing. Sometimes they respond and say, no, I'm not infringing because I'm not doing X, I'm doing Y. Well, you've just gotten free discovery there. You know what their defense is going to be. I mentioned the pre-existing exclusion for things that are already happening. There is a condition that you do have to be able to get an opinion. More likely than not, you should be successful. And that's important because if you don't have that opinion and you bring a case and the court says, you know what, you should have known that they weren't infringing. It was pretty obvious. You're going to have to pay not only your own attorneys, you're going to have to pay the other side's attorneys. But if you had an opinion before you went in, like we require for you to be able to get the claim, then you are that's a major factor that courts look at in not making you pay fees. A question we just got in: if an award is made but the award is not paid by the other party, you do have the benefit of stopping. You do have the benefit of stopping the other party. You do have us with you trying to collect on that. We will work with you to try to collect that. The policy does say if you win, you do have to make the payment back. You do, like I said, have that $100,000 forgiveness. And that $100,000 economic benefit relief comes in very handy early in a case. When you've started to make your case and the other side, you filed a complaint, maybe they filed an answer, you start having, the court may order you to have meetings to mediate whether this can be resolved. If at that point they say, fine, we'll walk away, and you've spent less than $100,000 on your lawyers, then insurance will have been, is not going to expect any payback because we've got that economic benefit relief at that stage. So here's an example of someone who had this kind of coverage. They had created a product in the pet care industry, pet grooming, and they had a patent on it. They had a trademark on the good name that they had for it. They had a infomercial produced, and then along came a grasshopper. Remember I talked about the grasshoppers? That's people who see an attractive technology and jump on it and start offering this pretty much the same thing. Knockoff artists, someone started offering basically the same product, gave it a name that was almost the same, so much so that people were calling our insured thinking that they were calling the other company, and they produced an infomercial and flooded the airwaves with it and copied nearly shot for shot the way that our insured had theirs set up. So they brought suit, they got the thing going, but it was still a small company. Our company by itself would not have been able to afford this. It took over $500,000 to get to the point where they were sitting down with the magistrate judge, with the defendant who came in with their, and they may have had lawyers being paid, they may have had an insurance policy for advertising injury there. They had lawyers, they had insurance people, and they just expected to see this little company with a lawyer show up and sit at the other side of the table who couldn't afford to litigate the full case. But when they sat down, there's the representative from the company, there's the lawyer, and there's the insurance company representative saying, we're behind this. We're going to pay for this. We're going to get this to a decision on the merits. The whole structure of the meeting changed, and their whole posture changed, and they settled the case and got a lot more many times more than what it had cost to get to that point, at which point the insurance carrier got back what they had put in on the case, but all the gravy, all the extra money stays with the insured, the intellectual property owner. We can't really talk about what the particular numbers were there, but it was in the millions. So that's the abatement coverage. It is a different animal than other kinds of insurance. And sometimes people will say, well, why do I have to have an opinion, or why do I have to pay back? There are dynamics in the intellectual property area, and especially in the enforcement side, that require that you do that so you can keep the program viable and make it available. We're happy to talk those things through, because I understand that those can be different for people to understand. Let's go over to the other side. Let's talk about defense. You know about defense insurance. That's what most insurance really is. Everybody has an intellectual property risk because of how broad intellectual property law is written. Anyone who is making, using, selling, offering for sale, or importing any goods or services can be accused of infringing on that. That can be the subject of a patent, whatever they're doing. It can be a method of doing business. It can be something that you bought from a wholesaler who bought it from a manufacturer, and you're just the retailer. You can still be sued because you're offering it for sale. Everybody in that whole chain of commerce is at risk. You don't have to own your own patent to be subject to patent risk. Sometimes people say, I don't need patent insurance. I don't have any patents. Well, do you sell any products? Do you offer any services? Well, then you are at risk, and you don't have to have your own patents. And sometimes you're most at risk then, because you don't really know what other people have, which, information that you might find out when you go to get a patent. One of the things you do find out is, well, there's already patents on that, and you can't have it because somebody else has that. So it's an area where everybody has a risk, and the defense policy is there to help you pay the cost and the damages or settlement if necessary. If someone finds out that you have insurance, they may be less likely to bring a frivolous case against you, or one that they're just looking for nuisance value, if they know that you've got the backbone, you've got the ability to fight this on the merits. They may not want to, just throw something at you and see if you'll settle quick so that they'll go away. You overall just don't have to spend your own money to get through that. Generally, the policies will include damages. You can select coverage without damages if you want, but very few people do, because it's all within the same limits. One of the things about being a specialized carrier is that we know what it takes to get through this sort of case, and we know that one of your strongest defenses, especially in the patent area, is to challenge the validity of the patent, and that patent never should have been issued in the first place. If you do that, if you're trying to do that on some other kind of insurance, they might say, well, why are you doing that? What's the cost? Why should I pay your lawyers to go to the patent office on that? We understand that that's an important part of responding and defending this sort of case, and that's explicitly included in the coverage under the defense policy. If you want to invalidate, if you want to send it back to be re-examined at the patent office, that's all within the scope of the coverage. And when we are looking at underwriting what you do, we have certain diligence we have to go through to see if you're already at high risk or not, to assess what the risk is. And we have to do a search. Now, you can either bring to us a freedom to operate opinion from outside counsel with your application that defines what you're doing and what you want coverage for, and why, after a diligent search, you're not infringing on someone else's rights. Or you can pay a fee and have us do that kind of search. We will do an insurability search. It's going to be a little different. We're not going to give you a fancy, long, expensive report that discusses the whole structure of patent law and everything that we looked at, and distinguishing everything point by point. But what we do costs a lot less, and we're willing to put our money where our mouth is. At the end of an attorney's freedom to operate opinion, it will generally end with, but this is no guarantee. Other reasonable minds may differ. Whereas if we write an insurability report, we will attach that to an offer for insurance to cover that. Or if not, to at least point out what we're not going to cover. Here again, defensive insurance, like other kinds of insurance, pre-existing things are not covered. And here what we mean is pre-existing threats. If you've already been sued, you can't get insurance against being sued. Or if you've already gotten a warning letter saying cease and desist or I will sue you, that's too late to get insurance. But as long as that hasn't happened, we cover you, including for the damages for having sold your product or service for however long you've already been doing it. We don't cut off damages according to when you had insurance. But you can't have been threatened or know of a problem that you don't disclose to us. As an extension of that, there is a 90-day waiting period before the case can be authorized. And what that means, if you are sued in the first 90 days, or if you get a warning letter in that first 90 days, you will not be covered for that. It is an extension of the pre-existing conditions that would not be covered. Now that 90 days is not lost. That 90 days of coverage moves to the end of your last coverage period with that same carrier. And so you're still getting a full 12 months worth of coverage for 12 months worth of premium. It's just that the first 90 days is not covered, and there is 90 days added to the end. Again, you do have to be able to get an opinion that more likely than not you can win the case. That may be based on the fact you're not infringing, or the argument that what's being asserted against you is not valid, that the patent should not have issued because there was, for example, prior art. There were people already doing it. It was not a true invention. That way, the policy does not cover pirates. It does not cover deliberate infringement. It does not cover what is dead on. If that is a problem, if that's a concern, if that's somebody that if somebody's applying and they say, oh, well, then I'm afraid I won't be able to get that opinion. We do have an endorsement available where you will have, you can have some coverage to try to settle a case if you can't get that opinion. But generally, we have not seen people having a difficult time getting, and like I said, that opinion needs to be more likely than not, 50.1% of the time. We know there's no guarantees in the law. This is not going to be, it's never a slam dunk. So what we want is more likely than not, 50.1% of the time, if everything's presented right, you should be able to win, is what we're looking for there. Here's an example. Octane Fitness was insured through us. They had an elliptical exercise machine that was getting a good reception in the marketplace, and a larger competitor did not like them taking market share. And they dusted off some patents that they found, and there were emails that came out where they dusted off words that they used and looked to see what they could throw at them to slow them down. And they didn't really do the diligence to see that there were differences, and the Octane machine did not operate in the way that the patent said. And so Octane won at the trial court, got summary judgment, and said to the court, we shouldn't have had to defend this. We should get our attorney fees. And at the time, the standards for when defendants could get fees awarded for a frivolous lawsuit were different than the standards for when a plaintiff could get damage or could get attorney's fees awarded if someone was infringing upon them. We said that's not fair. We went all the way to the Supreme Court, and last year the Supreme Court changed the law unanimously. And our Supreme Court in the United States today does not do very many things unanimously. But in this case, they did. And they said that the standards should be more fair, equally so for defendants or for plaintiffs. And it really changed the patent ecosystem to make it harder for people to assert frivolous lawsuits, or make it more dangerous for them to assert frivolous lawsuits, and make people more careful about when they bring an action. And so, like for our abatement insureds, getting that opinion is important to avoid being potentially held liable to pay the other side's lawyer fees under the Octane Fitness. We were there with them. We went to the Supreme Court. We came back, and they were a small company. They could not have afforded to spend 2 point whatever million it cost to get through this case as it was without the backing of the insurance. So we look at other kinds of insurance, and we, like I said, the CGL has a little bit in the advertising injury provisions, but it's very narrow and it's very limited. Now, it can only arise from what's in your advertising and not what's on the product. So if the claim is the name of the product or something about the product that infringes or a feature of the product that infringes, none of that's going to be covered under advertising injury. We know a lawyer who has used to specialize in getting coverage under CGL advertising injuries provisions for intellectual property claims. And a couple years ago, he wrote an article saying that was called Narrow, Narrower, Narrowest, in lamenting how hard it was to find a way to get coverage under the CGL advertising injury for IP claims. Why try to fit a square peg in a round hole? What we say is get specialized insurance for just that risk. That's what we offer. E&O coverages, we don't see patent being covered. Once in a while, you find some circumstances where trademarks or copyrights may be. D&O, we don't see intellectual property generally being covered. Professional liability is only if there's specific direct advice or services that was the direct cause of the infringement. It's a lot harder. Media coverage, generally we don't see patent coverage in those. There sometimes is trademark or copyright, but it usually has to arise from the media activities and not from the actual products or services that you're offering if they are outside of being something in the media as the primary product or service that you offer. Likewise for cyber. We're not seeing the same kinds of coverage for this. I was talking about Octane Fitness, and their CFO had some really nice things to say. When we got through with the Supreme Court and we got this case and we got this result that every patent litigator in America knows as the Octane Fitness standard now. Octane wasn't so interested in becoming a household name for patent litigators, but they did appreciate the way that we helped them through this. We got them hooked up with a legal team that was really good and was able to take that case from the trial court all the way to the Supreme Court and back, and do it in a very reasonably priced way so that they didn't burn up all their policy limits and be left paying everything out on their own. We worked with them. Insurance companies don't often get this sort of testimonial from their insureds. We were proud to work with them all the way through and to provide the service. And Ed O'Connor from Octane Fitness has offered to talk to people who have questions about our policies. No Sun was another one that, because they had the insurance, quote, I will never forget the conference call when our attorney dropped the bomb on them, that's the plaintiff who is accusing them of infringing, and said, our client has a $5 million patent insurance policy. Let's go. And the other side really changed their tune. That, oh, no, we thought that we were just dealing with a little company that we could bleed dry here. Because the insurance is there, sometimes the most valuable part about having this insurance is not having to use it. It's when the other side realizes you've got a big stick and they better back down. That can be an important part of having intellectual property insurance. So you're going to look at this, you're going to talk to people, ask them, do they have rights in intellectual property? Ask, do you have a name for your business? Do you have a name for your goods or services? Do you make, use, sell, or import anything? Do you have patent risk if you do? Do you know anybody? Have you ever been involved in a lawsuit like this? They can be difficult lawsuits to get through. Is what you're selling attractive in the marketplace? Because if it is, someone else is going to want to knock you off. Or maybe they're going to want to slow you down by accusing you of infringing on their intellectual property. Look around at your business. How many other people are involved in litigation? Is it just a matter of time before they get to you? Could you spend that money out of your pocket, or do you need to have another resource there? So, disclaimer, don't run with scissors. Your mileage may vary. We've not given you every term of every policy that we have here. That's why we're here. That's why we have information available. If you check us out on our website, patentinsurance.com, we've got a lot of examples of how things work. We've got industry examples that you can look at. We've got samples of premiums and things. And if you're looking for these slides today, we will make those available to you. So we'll take a look at the questions that we got. We do appreciate everybody being here with us today. We know that you're very busy people, and we do appreciate you being here. We had a question about when we have a claim on defense policy, do we need to see the CGL coverage form, or are we primary and non-contributory? And no, this is an excess policy. It is excess over other kinds of insurance. So if you do have CGL coverage potential, we will stand behind that. If you have a claim against them and they deny it, and we look at it and we say, it looks like you should have been able to get that covered, the policy will cover the cost of you pursuing your carrier if you're not successful at doing that. If you go after them and you're not able to get it, you can get reimbursed from us for those costs, because we expect those people who do owe you indemnity under an insurance contract or otherwise to live up to what they should do. We are going to be excess to that, but we can fund your pursuit of them if they should be paying and they're not living up to that, and that can be covered under your policy. I had a question about injunction difference. What is the difference in the policy and an injunction bond? Not sure what are we talking about there on the enforcement side. Bonds generally are. I think that I'm not sure on the exact terms for the bond coverage. There are going to be some coverage for if you do have to put up a bond if you're looking to get an injunction. Looking at other people out there, other carriers that are out there. There are some like RPX who have a subscription-based model that you have to be a member first before you can then buy insurance, and sometimes they will exclude a lot of the companies that they are related to who are patent holding companies, some of whom are patent assertion entities, and they won't cover you against those. But if you buy your way in, you can get some coverage there, but it's really a very different sort of provision. What we've seen in carriers who've been in this market, and we've seen a lot of people come and go. Over 25 years, we've been here consistently, steadily, every single year, always making the market. We've seen people come and go. And a lot of times what they'll try to do is to have some sort of a bailout or control term that says, yes, you do have to have a good case to start with, and we'll do an assessment of that somehow with outside counsel or on our own, and if we like it, we'll go with it, and if we don't, we won't. But they also seem to have a bailout in the middle provision that says if they don't like how things are going, they can drop the coverage anytime. We do not have that. We have the outside counsel opinion requirement that you get from an independent counsel, not from us. You get that from an outside counsel. And once that's in place, and once your policy once your claim has been authorized, you're in it, you're authorized, and we go forward even if things don't go well during the case. So I think that's one of the main things that we see as a trust issue, that we don't want to have a bailout in the middle if things start to look dark. It just doesn't seem right. Had a question about patent insurance for particular patents rather than insuring the whole company. And we do have to schedule On enforcement, yes, we do have to schedule whatever patents that you have. We will say we will enforce cover the enforcement of this list of patents, whatever you've given to us. On the defense side, we can, if you wish, write coverage just as against, like if you've got one particular company that has a couple of patents that you're concerned about, and your lawyers have said, well, we don't think you're infringing on those patents, but they might still come after you. And here's our opinion on why you're not infringing on those. We can write a policy that says, backs up that opinion and says, as to those patents, we will cover you under these terms. Generally, the defense policy will cover you for whatever goods or services are scheduled. So it is not a blanket policy. We don't say the Acme company is covered for anything that might come against them. We will say the Acme company's goods and services as described here, and then we will list what they are. Whatever it is that we're insuring against, we have to be able to schedule whatever goods or services you want to have the coverage for. So I do appreciate everybody's involvement today. We will make these slides available to you. If you have questions, like I said, patentinsurance.com has a lot of stuff. You can write to me or with somebody else here on our team. And thanks a whole lot for being with us today. Have a great day.